Court will begin today's session calling 2017-340 State of Arkansas versus Brad Sellers.
Your Honor, on Mr. Sellers, I think what the intent of calling his case today was, I think Mr. Etheridge wanted his mother, who is here, to make a statement to the court.
I would like that, please, Your Honor. This is a case that, again, sometimes it's victim-driven, and Mrs. Sellers has made a request, and I don't want her to put that on the record and tell the court her position in this matter, please, Your Honor.
All right, that'll be fine.
Ms. Sellers.
Mrs. Sellers.
Yes, sir.
We have Brad in here?
We do not, Your Honor. Mr. Cooper and I had agreed we wanted Mrs. Sellers to make this statement.
Oh, okay.
Your Honor, so the
Please.
court's aware this was a case in which Mrs. Sellers had filed a complaint and made allegations against Mr. Sellers, who is her son. Those allegations are quite significant as far as the state is concerned about what she had put in her initial statement. And she has contacted my office on numerous occasions and asked that this case be resolved, and I would like the court to inquire of her in that regard, please, Your Honor.
All right. Ms. Sellers, what can you tell me about this matter?
Well, this all started when an old girlfriend came back in and invaded our home. And she was a meth dealer and a meth pusher. And she was trying to get my son hooked on drugs, and she was doing things to him that was just making him flip out and do weird stuff and everything. And so I'd made up my mind that we were going to have to get rid of her somehow. And I had talked to 2 or 3 professional people. Nobody had ever given me any advice. So one morning, they were gone. Usually the car was parked out in front of the window, my window, and they were gone. I knew they were gone. And I had got up, and I was watching the property next door to us, and I'd opened the back door, and I heard a noise. So I was leaning out there to see if anybody was over there, because my neighbors had gone to Florida, and they told me to watch the property. Well, I watched, didn't see anything, so I darted in the bathroom, and I was washing my face and grabbed the towel and was wiping my face, and somebody grabbed me and stuck a hatchet in my throat. Well, I pulled the towel fell down is how it did. I didn't pull it. It just kind of fell down, and this was a guy that we'd seen. We had open policy at our home that anybody that needed a bed for a night could come and flop on our couch. And I hadn't seen this guy in a long time, and so I didn't recognize him. And his hair was short, his beard was shorter. And when he saw me, he got just white as a sheet, and he just dropped everything and took off. Well, I was pretty shaken up. And so I was back in my bedroom, and I got dressed and everything, and the house was completely quiet. Nobody was around. Everybody was gone. So I started out across the yard, and I saw a neighbor of mine, and I asked him, I said, would you take me uptown? And he said, sure. And I decided that maybe this would be a way that I could get this girl out of our lives. And I thought if I could just get a misdemeanor charge filed against Brad, and they would put him in jail, that then I could run that girl off. And so that's what I did. I said it was him that did it. And but the officer they sent up there was a green recruit. He'd only been on the job 2 weeks.
Okay, is that enough, Your Honor?
You know, this position of state is at the time these charges were filed back in February of 2017 that Mrs. Sellers made statements to the officers, in fact a written statement, where she stated that her son had held a hatchet to her throat and threatened to kill her. The position of the state had been, we did not wish to dismiss these charges. Mrs. Sellers has made it very clear to us she does not wish to move forward, but we want her to be able to say that to the court on the record and for her to understand the ramifications of that, Your Honor.
So at this time, based on this statement, you're saying that your son did not do this?
No, he wasn't even there. I was just trying to break up the relationship, and that's why I said that. Because I thought if I could get him out of the picture for a few days, I could run her off.
Well,
But the young officer, I had told him I only wanted a misdemeanor. I didn't want any felony charges brought. And
Well,
I
that's
don't know, when I found out that he had filed aggravated assault, I didn't even know what aggravated assault was. That's when I started the process to get it dropped,
Yeah.
because that wasn't what I had agreed to.
I understand your statement and your reason for making the accusation against your son. However, it really is there is a crime for making a false
I know it.
report, and
I
you
know
need to
it.
understand.
I understand that.
This is totally improper in terms of this.
I take full responsibility for that, sir.
All right. Court will receive the statement and we'll move forward.
Thank you, Your Honor.
Thank you, Your Honor.
Your Honor, can she be excused?
You may be excused. We'll call 2017-318, State of Arkansas versus James Davis. Mr. Davis Mr. Davis is represented by the Public Defender's Office, is that correct?
He's actually represented by Mr. Bailey. Mr. Bailey has the case either be set over until next week, if Judge Putman will take a plea next week, or if not, to February the 8th.
Okay. We'll,
There's Mr. Bailey.
Good morning, Your Honor.
good morning. This is the pretrial date in the case of State of Arkansas versus James Davis.
Your Honor, I've spoken with Mr. Davis a couple times in the last couple of weeks, and I think we'll be close to a settlement. Hopefully we can do that today. I know Judge Putman will be here next week, as will I, so hopefully within the next, if not today, within the next couple of weeks, we'll be able to enter a plea in this matter.
Well, I'll put him down for a reappearance on the my next date over here then, February 8th.
If we could have him brought over today, Judge, I'd like to go over the offer with him today and try to resolve it this afternoon if possible.
All right. I'll mark him to be called in the afternoon session.
Thank you, Your Honor.
Thank you.
I'll see you in a little bit, James.
All right. You may be excused.
Thank you.
2017-216, State of Arkansas versus Stephen Brown.
Mr. Brown and I visited yesterday. I know from that conversation where we are with Mr. Brown as far as Mr. Brown and I are concerned. Unfortunately, that does not, I think, equal where Mr. Etheridge and I are. So, having said that, I don't think there is anything that we need to do with Mr. Brown's case today.
This is the pretrial date in this case. There aren't any issues for
No, Judge.
pretrial at this
No.
time?
No.
Okay. All right. Well, the case is set for trial during the week of February 26th.
Steve, can I address him, Your Honor?
Yes.
I'll be over to the jail to see you next week with what Mr. Etheridge and I have talked about, all right?
Yes.
Okay?
All right, you may be excused. Your next appearance in court will be February 22nd.
Thank you, sir.
This is case 2017-444, State of Arkansas versus Scott Haynes. This case is for review today to determine the status of the case, whether it's ready to go forward. We have pretrial on March 22nd and trial during the week of May 21st.
The court will recall that we brought Mr. Haynes over last week, and we were not able to reach a plea resolution, and the reason for that was that he had pending charges in Craighead County. And during the 7 days since he was here, I've not been able to ascertain what Craighead County intends on doing. So I don't think we're in any more position today, Mr. Haynes, to go forward than we were last week if Craighead County is still that much of a concern of yours.
All right. Well, I'm just going to leave the case on for pre-trial on March 22nd. And hopefully by that date, we'll have some of those questions answered and either be able to resolve it or go forward towards
Your Honor, the hindrance that I'm having is that, as I understand it, Mr. Haynes does not have an attorney in Craighead County. Is that right, Scott?
Yes, sir.
And I don't think that he's applied for the public defender over there, so I will try to get answers, but I'm going to have to get them from the prosecuting attorney.
You'll need to apply, or make Craighead County aware that you're wanting appointed counsel, because we can't appoint anybody here to represent you over there, so it's going to have to go through their public defender's office or whatever mechanism they have for covering that. So it'd be very important if you would communicate with Craighead County.
Mark, did you inquire of Mr. Haynes, does he know what his charges are in Craighead County?
Mr. Haynes, can you tell us if you know what your charges are in Craighead County?
I've charged for marijuana pipe and that to beer because I've been locked up here.
Are they felony cases?
I believe the paraphernalia charges.
All right. Your next appearance in court will be March 22nd. You may be excused by this court today. Call 2018-33, State of Arkansas versus Michael Andrew Renfro. Mr. Renfro, the file reflects that this is your first appearance. You're charged with the offense of possession of drug paraphernalia related to methamphetamine or cocaine. It's a Class D felony. Have you made any arrangements to be represented by an attorney? You're not coming through very loud.
No, sir, I need an attorney.
Okay, so you don't have an attorney? Well, here's the situation. You're constitutionally entitled to be represented by an attorney. What that means is that you have to go out and hire the attorney of your choice. That's your right, to go out and hire the attorney of your choice. And while you're hiring a private attorney, the court doesn't get involved in the process. It's a matter of private contract between you and the attorney. If you cannot afford to hire an attorney, that's when the court becomes involved, because at that point, to be represented by an attorney, you're going to have to apply to the public defender's office. Applications for the public defender's office are available there through the jail, and you can get an application, fill it out, and turn it in, and it'll get to the public defender's office in order to get an attorney appointed to represent you. So you have to make a decision of whether you're going to hire somebody or whether you need to apply to the public defender's office, in which case you need to get an application and get that done. Do you understand that? All right. Well, at this point, you're charged with the offense of possession of a controlled substance, possession of drug paraphernalia related to methamphetamine or cocaine. That's a Class D felony. On those charges, how do you now plead?
I'm gonna apply for a 2020 attorney.
Okay. I understood you're going to apply.
I don't wish to make a plea right now.
Okay. Well, at this point, I'm going to enter a plea of not guilty on your behalf. You lose nothing by having that entered, You can change the plea if and when you talk to an attorney if you wish to. But I'm entering the plea of not guilty on the charge. Your case is on the Division III docket of Judge Putman, and I'm going to set you down to appear on February 1st in front of Judge Putman.
Yes, sir.
All right. You may be excused at this time. (2018-34) State of Arkansas versus David Fiss. Mr. Fiss, you're down for arraignment today on charges of theft of property, a Class C felony, theft of property, a Class D felony, theft of property, another D felony, fourth and a fifth count of Class D felony theft, another count of sixth and a seventh count, 8, 9 counts of Class D felony theft, and then a criminal, well actually 1 count of Class C felony theft, 8 counts of Class D felony theft, criminal mischief in the second degree, which is a Class D felony, and then theft of property, Class A misdemeanor, criminal mischief of Class A misdemeanor, criminal mischief 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 Class A misdemeanor, another criminal mischief, another criminal mischief, another criminal mischief, another criminal mischief, all Class A misdemeanors, and then residential burglary, Class B felony. 1, 2, 3 counts. Breaking or entering, Class D felony, 1, 2 counts. Then forgery, which is a Class C felony, 1, 2, 3, 4, 5 counts. And finally, fleeing in a vehicle or conveyance, a Class A misdemeanor. That's a total of 31 counts that I've read off here today. On those charges, how do you now plead?
Your Honor, he enters a plea of not guilty to all charges and waives formal reading of the arraignment.
Court is making the appointment of the Public Defender's Office to represent Mr. Fiss. I think you've represented him before, have you not?
Your Honor, he has pending charges also in the division.
Right. That's what I thought.
They are both here, excuse me.
Either I have or Mr. Bailey.
Yes.
So the Public Defender's Office is appointed. Plea of not guilty on all 31 counts is entered. This case is on the Division IV docket of this court. We're entering a scheduling order today. I believe I've already signed it. Yes, I've already signed it. It sets your case down for a trial date of May 21st of 2018 with a plea deadline of May 17th, a pretrial hearing set for March 22nd, and you're ordered to reappear on February 22nd. All of those dates will be in the scheduling order that I'm entering today. So your next appearance in court will be February 22nd. Your trial is set for the week of May 21st, and your pretrial is set for March 22nd. Do you have any further questions?
Yeah, is there any way I get a bond production? Maybe possible. Today?
Let's see. Let me look up where we are on bond.
Your Honor, on the first case, he has a bond of $50,000. On this case, his bond is $25,000.
Oh.
And was this particular crime, did it predate the other crime? Or at least his release from it?
Your Honor, this one occurred, started in November 28th through December 4th, and this one was December 18th.
Had he already been, when these allegations arose, had he already been out on bond on the other?
He's never made bond, Your Honor. They were separate cases, Your Honor. He was already arrested on the first one.
Your Honor, I don't know if Mr. Fisk has something he wants to say before the court makes a decision on bond. Since he is new to us this morning, obviously, I'm not in a position to articulate anything bond-wise, but I would ask the court to give him some leniency in addressing that himself.
All right, Mr. Fisk, what do you have to say in regard to requesting bond?
Well, Your Honor, I've lived here all my life. You know, I've always been cooperative with the courts.
I'm not understanding what you're saying. For some
And
reason, it's not coming through clearly.
You hear me now?
I
Your
can
Honor.
hear your voice, I just can't understand the words you're saying.
I've lived here all my life, Your Honor.
Okay.
I've been in compliance with courts with my bond on all my felony cases. I've never ran. I've always showed up. And got a
Well-
bond.
Well, do we know what the charges were in the previous case?
You know, they're the same type of charges, Your Honor. It's 18-24. It's the same thing: theft of property, criminal mischief, possession of firearm by a certain person, criminal trespass. And Your Honor, the court would ask the court to note the state has charged this individual in both cases as an habitual offender. We would agree he might not leave. The problem is he might continue to engage in this activity based on
That's what the
situation.
court is gonna say, is that court is gonna combine the bond into one, $60,000. The bond will be set at $60,000. That'll cover both cases. That'll be the bond. This type of breaking into homes is one of those things that, I'm not inclined to give you another opportunity to get out and resume that type of behavior. I recognize you haven't been convicted of it as yet, but given the number of charges and the number of burglaries and break-ins charged in this case and in the previous case, the court is going to set the bond at $60,000. Whether or not you're likely to run off, the court does have an obligation to ensure that you're not in a position to do more damage. So
Thank you, Your Honor.
that'll be the bond. It's a cash or professional bond at $60,000. Yes, sir. Yes, ma'am. 2017-122 State of Arkansas versus Osborne Gavel.
Your Honor, he is ours, and he was notified to be here, and I think in open court he was notified to be here also.
Well, that would be my recollection. Let me see. Court specifically notes that he was on the 18th of January. He was told to he was in court and was told to appear on this day. Court's going to direct a warrant shall issue.